What makes a will legal in Washington state? Well, with a lot of legal questions, the answer is it depends. So let's break it down. The will is prepared in Washington state. If that's the case, then the will must meet certain formalities. It must be witnessed. It must have the signature of the person who signed it, and it must be made by somebody who understands what they're doing. They have to have testamentary capacity. They need to know who they are, who their family is, what their assets are, at least in general, and who are they giving everything to. So an estate plan, a will in Washington has to meet certain formalities. Now, with a will, you'll often see that it is witnessed by two people. And then there's the next page that's called an affidavit or a declaration of the witnesses. This makes the will something that we call self-proving. What that means is at the time of the person's death and the will is submitted to the court for probate, which means to prove up the will that it's valid, that the people who witnessed it don't actually need to come to court to testify. Instead, they've already done a declaration or they've already done an affidavit at the time the will was signed, and that's what makes it self-proving, and that makes the process much easier. So in Washington, it is really important that all the formalities of a will are met. Now, if the will was drafted in a different jurisdiction, that jurisdiction might have rules that say a holistic will is valid. Now, what does that mean? So you probably heard people say that, you know what, they wrote their wishes down on a napkin. They did certain things that would totally not be accepted here if it were done in Washington state, but it is in a different jurisdiction. So a handwritten will, maybe that doesn't even have witnesses, might be valid in another state. And if that's the case, when it's submitted in Washington, Washington is supposed to accept that will if it's valid in a different state. Now, will Washington accept the will? That it depends, because a will that doesn't have all the formalities is very much susceptible to argument that really wasn't meant to be the last will and testament. It was just somebody writing down notes, etc. So don't do a handwritten will. Do a will that is at least witnessed by appropriate witnesses. That means they can't be related to you. They can't be inheriting from you. I could go on and on with the rules, and I'm going to stop. In order to make sure that your will is valid, see your estate planning and elder law attorney and make sure it's done right.